we have a quorum at this time. I'm going to go ahead and call the meeting into session. Mr. Williams will rejoin us, I'm sure, momentarily. Good morning, everyone.
Morning.
At this time, the time is 9:07. Today is Wednesday, April 28th, 2021. Calling this meeting into session of the Wayne County Ethics Board. We are now in session. Moving on to the agenda. Our agenda for today, we're going to move on to item A, which is roll call. Ms. Kangura, is she present?
I'm here.
Can you do roll call for us, or is Ms. Lewis available?
No, I can do it.
Okay,
each member is acknowledging that they are attending the meeting via Zoom and that they are located in Wayne County, Michigan, unless otherwise stated when I call your name. Mr. Young?
Also, before we start, Mr. Young just called me and he said he can't attend. He's excused. So
understandable.
Okay.
Thank you.
Mr. Thomas?
Present in Wayne County.
Mr. Hendricks? Ms. Hamoud?
Good morning, present.
Dr. Carnell?
Present.
Chair Pinkins?
Present. I'm in Wayne County.
You have a quorum.
Thank you, Ms. Kangura. Moving on to the next item of our agenda, which is item number B. We're at the approval of our March 1st, 2021 meeting minutes. Just going to ask all members if they were able to get a copy. They did receive a copy of the meeting minutes from our last meeting, the March 1st meeting. And if all members had the opportunity to review the meeting minutes.
I did.
I did.
Yes.
Are there any questions or concerns regarding the minutes?
None on my behalf.
Not here.
Okay,
No.
all right. Is there a motion to adopt the meeting minutes from March 1st, 2021 meeting?
I'll make that motion.
Is there a second?
Second.
All in favor?
Aye.
All opposed? The ayes have it. The motion is carried. Moving on to our next item, which is our item number C, which is the unfinished business. Before I get to this item, I'm just gonna make one quick comment. Mr. Slezak and Ms. Kangura, someone, if you can answer this question for the chair. I was looking at the email that went out containing our agenda and the package for this meeting. It wasn't addressed to the board members. It was addressed to, I'm just looking at the letterhead here on the head of the email. I mean, I can't even begin to count out how many people this was sent to, but at the bottom here, the board was CC'd. And I'm just trying to find out, it seems like this is from Ms. Kangura. Ms. Kangura, I know you're new to the board, and the chair is not going to be harsh with you. I'm not trying to offend you in any way or come down on you. But can you ask me, why was it done this way? Why was all these people sent a copy of the agenda and the package, and the board was just CC'd?
I apologize, Mr. Pinkins. I meant to BCC the board. I did not realize that I CC'd them. Normally we have mailing lists. We have the regular mailing list, and then we have the board mailing list. And I just noticed that I did not BCC the board as I usually do. So I apologize. That's my mistake.
Why is it that we're sending all of our agenda and packages for our meeting minutes to all of these different people? Some of these names are here, I don't even know who these people are. So I'm just trying to figure out, how is it that is that something you were instructed to do? Because I'm just trying to figure out how, the chair is trying to figure out how is it that our package and agenda and meeting materials are being sent to all these people. There's nothing wrong with putting up on the website for transparency purposes. But I'm just trying to understand, why are all these people, we're sending a package to all these different people before the meeting? And again, I'm just trying to gain some understanding.
So this is Pamela, the Director of Policy Research and Analysis, and I don't know if Felicia is on the phone or not, but I'm just going to jump in and say that for our commission meetings, this is the way we do it, because we try to provide as much notice to as many people as we possibly can that a meeting is taking place, so that if they want to participate, they can. So as far as I know, we didn't do anything different for ethics. So we continue to follow that same philosophy. We reach out to provide as much notice to as many people as we can. And these are the people who are normally interested in what's happening with our commission meetings, because this is a part of or came from the commission, we just continued that same practice. So if there's something different that you want to be done, we can discuss that.
Yeah, and thank you for answering my question. Thank you for coming in to address this. Yeah, because the chair is concerned. Just because it's one thing to let everyone know that the meeting is taking place. It's another thing also to for full transparency purposes, to have it up on our website. But when you're sending a good 100 people here copies of our agenda and a package of complaints and everything else that's been filed before the meeting actually takes place, my concern is the possible influence that could come about. And so the chair is concerned that not to be sending this out to all different departments. I'm not aware that this board has ever received any packages from any other meetings from any other departments. And we know that the departments are having and conducting monthly meetings, but this board does not receive packages from any other department. So the chair's concern is for this board to be sending out packages of our meetings, our agenda to various departments and people who are not even, I'm not even sure if they're even in these departments, receiving a copy of the package. Again, I'm not going to belabor this point, but I just want to just make sure that in the future we make some changes with respect to this, that one, the board should receive, we should not be CC. We should be the direct recipients of our board agenda and package. And some of these other people, one, it should be placed on the website. It can obviously go to the website, download what they want to download, but to send it directly to them, the chair is a little bit concerned of any possible influence that may take place. We do receive complaints from various people, often regarding various department heads, elected officials, employees. So we would not want the possibility of influence prior to a meeting to take place. So with that said, I'm going to move on with the agenda.
And I'll contact you after the meeting, Mr. Pinkins, and we can finalize the list.
Great. Thank you so much for that.
Mm-hmm.
All right, moving on to the next item of our business, which is item number C, which is unfinished business. Number one, there's a presentation of a certificate to former board member Sandra Buciero. I did get word from Mr. Slezak. Is Ms. Buciero present, Mr. Slezak?
I don't see her. I mean, she emailed me last night that she would. Oh, yep, I do see her now. She is here. She's on mute right now.
Good morning, Ms. Buciero.
Good morning.
How are you?
Good. How are you?
Good. It's good to see you.
Good to see you too.
Thank you for being present today.
Thank you.
You know, as we do and as you've been a part of in the past, we were obviously sad to see that you weren't rejoining us for another term, but this board has taken liberty to prepare a certificate of appreciation that we wanted to present to you. Speaking from the chair himself, I would say it was a pleasure to have served with you. You brought a lot of insight and light to this board, and you'll be surely missed. Again, we just wanted to present you with this. I know if any other board member wanted to chime in and say some things, they can obviously do so. But the members that you served with, including this chair, just wanted to extend our appreciation and gratitude for your years of service.
Thank you. It's been an honor to serve, and it's been an honor to serve with a wonderful group of people. It's been a great experience, and I was happy to do the good work that the board does. And thank you very much for the recognition. I appreciate it as well.
Okay. Thank you so much for those words. So what we're going to do is we're going to get this certificate out to you. I know Mr. Mr. Hendricks and Mr. Young could be present. So we'll get this out to you as soon as possible. And again, thank you so much for being here.
Thank you.
All right,
Thank
so I'm
you,
going
Ms. Buciero.
okay, I know the chair is moving right along. If there's anyone who wants to make a comment or something, please feel free to interrupt the chair at any time. At this point, I'm going to move on with the next item of our agenda, which is item number 2. We have the complaint from Mr. Thomas Broich regarding Wayne County Board of Canvassers member, Elias Monica Palmer. I believe at the last meeting, it was determined that the board found that there was no conflict of interest. uh, in the roles that Ms. Palmer played on the Wayne County Board of Canvassers and in her capacity with the Grosse Pointe Public Schools, her nonprofit organization. But we did find that there was incompatibility of those roles. And today we're moving on to the penalty phase. So at this point, I'm not sure if Mr. Williams was able to rejoin us at this time.
Yes, he's here.
Mr. Williams, at this point, this chair is just going to sort of chime in and ask for your sort of expertise in this matter, or to advise us in this, because I'm not certain if, with respect to the incompatibility aspect, if that's an actual violation of the ordinance. If there's a violation of ordinance, obviously we look at the ordinance itself and we look at our operating rules to determine the penalty phase. But is it your understanding that the incompatibility serves as also a violation of the ordinance?
Well, I guess in the strictest sense, Mr. Chair, I think it does violate the ordinance, at least as it relates to holding an incompatible office. But as it goes to the penalty phase, I'm not sure what penalty could be imposed for such a violation. I don't think we've had an incompatibility finding under any other situation, because normally the incompatibility concept has been more addressed by people asking us for advisory opinions on the subject of whether they can or cannot hold sort of or take a incompatible action. I think in the strictest sense, I'd have to say it is a violation of the ordinance, or at least a violation of the chapter under the language of the ordinance as written. And I think that then you go to what would be the penalty for it, and that's a tougher situation to come up with an appropriate penalty for such a violation.
Well, since you say that you feel that there is a violation, that the ordinance is violated with the incompatibility aspect, then what I'll do is, looking at page 16 of the ethics ordinance, it does say here under subsection B, in the event that the board determines that the ethics ordinance was violated, the positive determination of all findings of fact shall be reported as follows. Moving down to subsection 3, it says here, if an appointee is involved, the positive determination shall be forwarded to the appointee, the Department of Personnel and Human Resources, and the appropriate elected official, and for disciplinary consideration, as appropriate, and shall be published in the transparency section of the Wayne County website. So that's one area to proceed. Looking at our operating rules and procedures, thus says on the third page here, I'm looking at, it says, and I'm just making sure all board members have a copy of our ethics ordinance rules and procedures, operating procedures. Any members doesn't have a copy of the rules and procedure for the Wayne County Ethics Board, just let the chair know. We'll make sure you get a copy. But I believe at this point, all members have a copy of this. But here on the third page under subsection M, it says, if the ethics board determines that the ethics ordinance was violated, then it shall direct the chairperson of the ethics board to issue a municipal civil infraction violation notice instructing the respondent to appear in the Wayne County Municipal Violations Ordinance Bureau to pay the fine and cost prescribed in this chapter. Looking at I believe it's page 18 of the ethics ordinance, or excuse me, I think it's page 18 of the ethics ordinance here. Says a violation of this chapter shall be a municipal civil infraction punishable by a fine of not more than $500 in costs, in addition to any other penalty, whether criminal or civil, a public servant who violates the chapter may be subject to. So at this point, what would be your recommendation, Mr. Williams? Upon hearing that language, what is your opinion? And then we'll put it to the board for discussion.
Given all that has happened, I guess my opinion would be a municipal civil infraction fine of $100, given, what I think is a particularly confusing situation that arose and got a lot of notoriety, but I don't think there was intent or a situation where Ms. Palmer was engaged in activity that at the time she thought was a violation of the ethics ordinance. So that's my recommendation.
Okay. All right, thank you for that, Mr. Williams. Now at this point, I'm going to open up to the board members to discuss Mr. Williams's possible opinion or recommendation. If the board has any other opinions or recommendations it wants to come up with. As reading from the procedure, it does say the board finds, and the board is to direct the chairperson to do such. So again, this chair will take its direction from the board as it would have, as the board would have the chair to proceed. So opening up now to the board members for your input on this matter. Any board members have any discussion on this?
I have per chair.
Yes, Ms. Hammoud.
So because of the incompatibility, I mean, the one thing is like we have to solve the incompatibility. So I'm looking at the ordinance and on page 18, section D, and I'm looking at the actions that we may not be able to take, but the employer or the, in this case, maybe the body that appointed the individual, that they would be able to take some actions, whether remove or reprimand or censure. And in this case, I think the board should recommend at least to be able to solve for the incompatibility in addition to any like fine. And I kind of agree because this is kind of the first time, and Ms. Palmer didn't know that, maybe I wasn't aware that the actions taken were a potential ethics violation. So the 100, I think it's fair. But in addition to this, we want to make sure that we are sending the message, for not just in this case, but any other cases, that there should be some consequences and there should be a remedy. So you can't just have those incompatible positions, even if they don't provide conflict of interest and potentially like monetary in case like the conflict of interest situation. So thank you.
Mr. Chair.
Yes, Mr. Williams.
Just a point of order. I should note that I received it at about 6:30 because I was caught up in something else yesterday. I did get an email from Mr. Schwartz yesterday in which he provided me with, I guess, minutes of a quarterly meeting of the directors of the taxpayers for Grosse Pointe schools that included their efforts to dissolve the corporation, which I guess is going through the process at the state and needs approval from the state attorney general to enter a certificate of dissolution for the corporation. So Ms. Palmer has taken steps to, I guess, dissolve this particular entity that may in part address Ms. Hammoud's concerns about a potential affirmative step toward eliminating the potential for incompatibility for this entity in which she is a party.
Thank you.
You're welcome.
Thank you for that, Mr. Williams. Thank you for sending that over to us as well, Mr. Schwartz. Okay, is there any other members that would like to add any input on this matter?
To the chair, you mentioned information posted on the website. Could you elaborate on that, please?
Information posted on the website? I'm sorry.
I thought you said one of the penalties or,
Oh, I'm sorry. Oh, yes, Dr. Cornell, on page 16 of the ethics ordinance, subsection B, subsection 3 says, if an appointee is involved, well, first off, subsection B says, in the event that the board determines that the ethics ordinance was violated, the positive determination and all findings of fact shall be reported as follows. It goes through various, if it's a county employee, then subsection 2, if it's a contractor. Subsection 3 will be relevant here. It says, if an appointee is involved, the positive determination shall be forwarded to the appointee, the Department of Personnel / Human Resources, and the appropriate elected official, and for disciplinary consideration as appropriate, and shall be published in the transparency section of the Wayne County website. So the chair would assume that whatever is determined, whatever penalty is meted out at this time, that we would instruct Mr. Williams or his staff to notify the various parties, as well as to have it published on to the Wayne County, the transparency section of Wayne County website.
I support that and the $100 fine, as our attorney has suggested and recommended.
Okay.
Mr.
Thank you for that,
Pinkins,
Dr. Yes.
Mr. Pinkins, I do have a couple comments when the doctor is complete her statement.
Are you
I'm done,
finished, Dr.
thank
Curry?
you.
Okay.
Yes, I am, thank you.
Mr. Thomas.
I would just like to state for the record that the reason that I'm supporting and I will support Mr. Williams' recommendation is because of the affirmative action that has been taken to remove Ms. Palmer from a situation where she's involved in a group that caused her to be brought before us. I would ask this, while I am supporting what has been recommended, I would like to know that at some point in time, when that political group that has brought this matter before us has been finally resolved or disbanded or whatever terminology is used by Lara, I would like to know that Mr. Williams got a copy of that from Mr. Schwartz. And with that, I agree with everything else. I would just like to have that level of follow-up to see that that was done, because that was a concern that I had at the last meeting concerning incompatibility and her continued involvement in that group. And I'm finished. Thank you.
Thank you for that, Mr. Thomas. Mr. Williams, if this recommendation is adopted, would you please follow with Mr. Schwartz to make sure that we receive all final outcomes regarding the dissolution of the Grosse Pointe for Taxpayers nonprofit organization with respect to Mrs. Palmer's enrollment or involvement with that entity? Yeah.
Yes, Mr. Pinkins, certainly I will. And I know Mr. Schwartz is on the hearing, so I'm sure he's aware of his need to follow up with me to make sure I receive the updated information regarding the status of the certificate of dissolution and approval process through the Attorney General's office.
Okay. All right. So at this point, the chair is going to assume that the motion is before the floor. Is the recommendation from Mr. Williams with respect to the penalty being $100 civil infractions imposed, as well as Dr. Carnell mentioned the posting of the penalty phase to the Wayne County website, as well as contacting the various personnel agencies and the appointing officials for Ms. Palmer to let them know the outcome. Is there a second to that motion at this time?
Second.
All in favor?
Excuse me,
Aye.
Mr. Chairman,
Excuse me.
do I not have an opportunity to speak on behalf of my client?
Okay, well, let me just back up a minute there, because we did put a motion before the floor. Are you attempting to speak before the motion, Mr. Schwartz, or are you?
Yes, because if I speak afterwards, it becomes moot.
Sure. Okay, well, while we do this, while we table the motion for now, and we'll allow Mr. Schwartz, because this chair did not allow Mr. Schwartz the opportunity to speak. We did move right into the motion phase of this. So what we'll do is table the motion at this time. Mr. Schwartz, you have the floor.
Thank you very much, Mr. Chairman. Firstly, I want to indicate to the board and to Mr. Williams that when this document, which has been sent to Lara, but which has been put over to the Attorney General, is completed, and I don't think there's going to be any problem. It just takes them the time for processing. I have no problem whatsoever, and my client has no problem whatsoever in presenting it to Mr. Williams for him to have and disseminate if necessary to members of the board. That's not a problem. When we get to the issue of what the outcome should be in terms of this matter, I noticed some things, and I think that the board itself has shown some good recognition of what was going on. Number one, as Mr. Williams indicated, this was what he said was a confusing situation. And I have to say that I agree with that. You take a look at this, and again, it seems to me, based upon what I've heard, that there are probably very few, if any, people who actually understand the incompatible roles of different things. We have, for example, a previous member of the canvassers, Mr. Kinlock, who was and is, he's now, I think, on the Wayne County Commission, but he was with the 13th district or 14th district, I don't remember which one it was. He was chairman of that commission or that board or whatever they called the committee that would be involved with the political party, the Democratic Party in his case, concerning matters. Now, he did that. There were people who would come in and as position that he had in that political situation, he would be doing things that could involve elective office, which not necessarily for him, but for other people who come before them. Because these types of committees, generally speaking, are populated by people who are very involved with political matters. The average person doesn't even know about these committees necessarily, but they do that. And there's a reason for them to do that, because it's important for the various different political entities to be able to get together, do what they have to do, and get their people out to the polls, and also to get people who would be candidates for office who would come in and seek to be elected. Now, he had those two positions, and I don't think that Mr. Kinlock would have known that what he was doing there may very well be what it was that my client, Ms. Palmer, was doing. In other words, you could have people who are involved in things that could end up, and this is speculative, but could end up where there are people who are involved with elections where at some point there may well be an election which the canvassers will deal with at the end of the election. So I think that what happened with my client, it just so happens that nobody went out in the case of Mr. Kinlock and filed a grievance, to the best of my knowledge. In this particular case, Mr. Bruch filed one against my client in another situation, but under similar circumstances. By the way, I'm looking right now
Mr. Swartz.
at the board. There's something that's getting on there. I don't know why that's on there.
Excuse me, Mr. Swartz, not to interrupt you for one quick second. Ms. Kongura or Mr. Slizak, whoever has control of the comment section, can you turn that section off for us? If someone is posting comments while Mr. Swartz is talking, and that's very offensive and disruptive, you just turn that comment section off. Okay, thank you, Mr. Swartz. We'll let you continue, sir.
Thank you very much. And What we have over here then is a situation where this board, from the members that I've heard of today, appear to understand that what my client has done is not something which she did with an intent to engage in any violation of the ordinance or anything else for that matter. I think also we have a situation where we understand that there were two different charges, if one might say. One was conflict of interest and the other is incompatibility of the two roles, one being with the committee that was involved with Grosse Pointe Schools, and the other of which is her role as a canvasser. Now, I don't know, and I don't know that anybody knows at this point, whether or not it would be something that would be known by the average person, that would be, in fact, incompatible. I don't think, in fact, I will tell you, because I have talked about it, she didn't know, because I've talked to her about this, she did not know that would be viewed as being incompatible offices. So what we have is a situation where somebody comes before this board not knowing that what they did would be viewed by this board to be a violation of the ordinance. And as a result, we had a hearing. There was a decision by the board, and now we're at what would be the equivalent of the sentencing session. Now, looking at the ordinance under page 18, which is under section 40-10 C, which is what we had reference to. It says a violation of this chapter shall be a municipal infraction punishable by a fine of not more than $500 in costs. The only problem with that is this. It is similar to, and I think, there are people here who are knowledgeable about things that happen in courts where people are charged with offenses of different types. The offenses, generally speaking, can have various different results. There can be a decision that there should be no penalty. That's one. There could be a decision that there should be a penalty of some type. That's two. There could be a decision that there be solely a fine, which appears to be what I'm understanding is here. Or there could be a decision that there is no fine. When I take a look at this, one of the things I think that we have to look at, amongst everything else, the average person out there in the world at large will not know, even after this goes through, whether or not certain types of actions are or are not a violation of the ordinance. The ordinance is written as it is. It is not detailed to the extent that this type of situation that we have here would be clear and obvious to most people who would be looking at it. Certainly, I don't think it's necessary for somebody to have to be a lawyer well vetted in this type of situation to be the type of person who would have to know. The average person who sits on all of these different committees and all these different roles, appointments, etc. I would venture to guess that most of them are not lawyers, and I would venture to guess that the average lawyer doesn't even know about these things, because most lawyers are involved in other types of practice of law. They don't get into these types of legal matters. So what I'm suggesting here is that there be a situation where my client is not held. It could be kind of like, I know that Mr. Thomas is aware of these types of things because he used to be with the Attorney Grievance Commission, and he also represents lawyers who are charged with types of things that involve discipline. And there are situations where you can have something where there is, under those rules, no discipline. And the reason is that in some cases it becomes pretty clear that, and I think that it's been enunciated here by the board, and I think that the board is correct, that my client did not engage in conduct with any intentional object of violating this ordinance. When you read all the things in the ordinance, I think it is not clear. I think one of the things that needs to be done above and beyond everything that has been mentioned is that perhaps there should be a little bit of a revision of the ordinance to make it clearer to people who are potentially subject to the ordinance, to know what it is that they can do and what it is that they cannot. Because one of the things that we know is that generally due process requires us to know what it is that we cannot do before we're to be held account for that. And what it is that we cannot do in this particular case, I'm suggesting, is, as Mr. Williams indicated, is what we would call confusing. I will say even, and I am a lawyer, and I do a lot of this type of disciplinary work, not only involving lawyers, but other people and other members of different professional occupations. I have not seen something like this that is as lacking in detail as to what it is that one cannot do. And I'm not here to criticize the people who wrote this ordinance. All I'm saying is, if something is going to happen, if people are going to be told you can't do these things, and it's important, I think, as I believe Ms. Cornell indicated, that there should be something so that people will know what it is that they shouldn't be doing. I agree with that. And in order to do that, one of the things that should be there so that people will have something to look at is that, which is not in the ordinance, to wit, something more detailed so that people who will be subject to this will know what it is that they should not be allowed to do. And having a situation such as what we have here, I think, is questionable in terms of what the average person would know. Obviously, Mr. Kinlock didn't know, because if he knew, he wouldn't be doing what he had done. Not to say that there's anything that he did that's wrong, because I'm not here to accuse him, but it's kind of a similar situation. I don't think that he would have understood what it was that he couldn't do, because if he did, and it was clear to him looking at the ordinance that that would be prohibited, then I think he wouldn't have done what he has done in the past. So I think that should be looked at, because when we're looking at what here is now the element of sentencing, you look at everything that went on, you look at all the things that happened, you look at whether or not this was intentional or this was a mistake, or this was something that nobody, generally speaking, would even know. It's something that should have happened. So that's why I'm asking that we find that there be no penalty imposed.
Okay, Mr. Schwartz, thank you for that.
Mr. Chairman?
Yes, 1 second, Mr. Broach. Let me stop you there. Yes, Mr. Broach, I'm gonna allow you to come in and give you equal time to make a statement as well. Go ahead, sir.
Yes, thank you, Mr. Chairman. I don't need equal time. I'm going to be very brief so that the committee can get on with its business. Thank you very much. Just a few comments, though. One is, as we all know, ignorance of the law is never an excuse. The law is what it is. If you violate it, then it's the board's charge to enforce it, along with the appointing authority, who I guess will make the ultimate decision here. With respect to what can and cannot be known or what the statute or the ordinance provides, it seems obvious to me that one who supervises our elections should not be spearheading and sponsoring recall campaigns where recall elections may in the future come before her, and should not be sponsoring a political action committee that's participating in elections, advocating for the election of candidates, and then having those elections again come before her as an election supervisor and canvasser, and someone who might have to do recounts and perform other obligations. It seems very obvious that anyone in that position as a Wayne County Board of Canvasser should understand that there are just some things you can't get involved with that are very obvious conflicts of interest. And so I think that that should be clear. Also, I would ask that when you report, as the ordinance indicates you should, to the appointing authority for its ultimate decision in this case, that the record should be clear that although Ms. Palmer appears to be disengaging from the Political Action Committee or requesting its dissolution, apparently no efforts have been made to disengage from the 2 recall campaigns that she's currently sponsoring against Grosse Pointe Board of Education members. I know that was an issue that was commented on at the last meeting and was of some concern. That's something that obviously could come before her as a Wayne County Board of Canvasser, and that she would again be supervising her own advocacy in trying to recall Board of Education members. There's a lawsuit that remains pending on an appeal of her petition. She has not offered to withdraw from that lawsuit or stipulate to its dismissal. So those efforts are ongoing and still subject to the same kinds of issues and conflicts that we saw with the Political Action Committee. And with those statements, I again thank the board for its attention in this matter. It's an important one. I think it will help guide the conduct of individuals in the future. And I think this board can do its part to make sure that the public has confidence in its elections and in its public officials. So thank you.
Thank you for that, Mr. Broich. With respect to the comments that were just made from Mr. Schwartz and Mr. Broich, I'm going to put it before the board again for discussion. Any board member have any input they want to add at this time with respect to the matters raised by Mr. Schwartz and Mr. Broich, with respect to the penalty phase for Ms. Monica Palmer?
I do, Chair.
Yes, Dr. Carnell.
The only thing I just want to correct is a statement made by Mr. Schwartz that the reason why I wanted it posted on the website is so that other people would be aware of the ordinance or possible violation. My rationale for having the transparency on the website is to show that the Ethics Board did its due diligence and that people could see the outcome of this issue.
Okay, thank you, Dr. Carnell. Are you finished? Okay.
Yes, I am. Thank you.
Thank you. Any other members at this time?
Per Chair.
Yes, Ms. Samula.
Yeah, I mean, I do agree with earlier comments about like the average person and they may not know. The thing is, like, when someone is in position, whether Cancer Board or our board, I mean, I'm assuming, and we did confirm with the Wayne County that, and with Ms. Palmer, that she did have a copy of the ordinance. And I just want to make that, you know, for the record. And then also, I do, as an like average person, and I'm not an attorney, I actually was surprised that the canvassers board are from 2 political parties. I mean, I would have assumed if there should be a change, if you ask the average person, there should be some independent, but we can't make that. It's not in our jurisdiction. So that's why I have to do, and my earlier comments were regarding what we can do to be able to correct the incompatibility. And I do, you know, that's why I recommended like to be able to resolve, in addition to any fine, to be able to resolve the incompatibility. And I kind of tend to agree. If there are recalls, if there are any lobbying or to a specific campaign or a specific candidate, that person shouldn't be on the canvasser board. If they're making a position or making a decision or duty, official duty, they should excuse themselves at least for that portion. I mean, they should not be voting on something that they are involved. I feel like this totally not right. So that's my comment.
Thank you for that, Ms. Hamud. Any other members this time?
Yes, yes, Chair, I have some comments I would like to make if Ms. Hamud is finished.
Yes, Mr. Thomas.
Okay, well, what I would like to do is I would just like to refer back to page 18 of the Ethics Code, subparagraph C. It states very clearly that a violation of this chapter shall be. In the law, shall be, those are very, very critical words used in a code like the Ethics Code. Shall be, that means that you literally lack discretion. It says to me that we have to do something. Now, what I would say would be this. I want to thank Mr. Schwartz. I want to thank Mr. Bruce for their comments. They were very, very helpful. I want to get back to Mr. Williams' comments that he made. He used the word confusion. He was very eloquent. And let me tell you why I personally am supporting what has been recommended here by Mr. Williams and the other board members. I believe that when Mr. Williams was speaking, he was taking into consideration the fact that this is a case essentially of first impression. We haven't had a lot of litigation regarding this area in the past. I believe that the penalty that he recommended is really, it's not even the maximum fine. It's a municipal civil infraction. I'm just looking at this as being a case where we found that the roles that Ms. Palmer engaged in were incompatible because of her position on the board of canvassers. I don't think that we have much of an option. You know, Mr. Schwartz said, well, you know, in some areas, in some realms, there could be a finding of misconduct, but there's no penalty imposed. Well, in those proceedings that I know of, in particular, the attorney disciplinary system, there's not language that says shall be, that there is discretion within that system for imposing no discipline. I believe what Mr. Williams said about Ms. Palmer not having any intent. I believe that. I accept that. I accepted that all along. I really wish that people could turn back a clock, and I wish that prior to the time that this case was brought before us, she might have resigned from that position before. But here we have today a situation where we've got a finding of a violation, and I think that what has been recommended by Mr. Williams and is discussed by various board members, including Dr. Carnell, about it being posted on the website so that the public knows, so that almost like an educational process is the way I interpret it. That's why I'm supporting Mr. Williams' recommendation. I just wanted to get those things out on the record.
Thank you, Mr. Thomas. Thank you for that. And just from the chair, I just have a couple quick comments as well. The chair did note Mr. Schwartz's statements, and the chair will commend Mr. Schwartz for doing obviously an admirable job of defending his client in this case. However, I would say that the argument of no knowledge of the law, obviously, as we've heard, is no excuse. Lay people know this, attorneys know this. If, you know, and I am an attorney, if I was to argue before a judge about my client's lack of knowledge of the law, obviously no judge would listen to that argument. And so that's not an excuse. I also get to the knowledge that or the testimony that she gave when she stated that she had read the ethics ordinance. She fully knew what it entailed. One could argue some of those areas are a little bit unclear, but it does speak to the incompatibility of employment. It could be reasonably foreseen by a person that her operating in these dual capacities could be seen as incompatible, or, as was mentioned, a conflict. This board didn't find a conflict of interest, but it was very close to doing so. So I do think, with respect to that, it was very close, and I think she knew or should have known of the incompatibility roles. Also, in the past, this board has entertained, as we're going to do today, many requests for advisory opinions. People from all walks in the county government, employees, elected officials, appointees have come before this board when in doubt and have asked questions about possibly a conflict of interest or incompatibility, and what so as it relates to the ethics ordinance, and this board has given their opinion. That could have been done as well. We don't want to get to a point where we're setting a precedent where someone is violating the ethics ordinance, and we're just sort of getting a slap on the wrist, which this chair would feel $100 violation would pretty much be tantamount to sort of a slap on the wrist. It's saying that we acknowledge that you didn't have intent to violate the ethics ordinance, but you did do it. Okay, there was not the intent to do so, but you did do it anyway. It's sort of like I'm speeding down the street and I'm doing 45 and at 25, the officer stops me. I can't say, officer, I didn't know this was a 25-mile-an-hour area. I'm still going to get a ticket. Okay, so you didn't mean to, you didn't intend to, but you did anyway. So there has to be some punishment for the violation. The rules are there not to be broken. So with that said, if there's no further comments, this chair is going to move forward with the motion that was tabled. We'll bring back the motion. And if there is an adoption of the motion, and let me just repeat the motion itself. The motion as recommended by Mr. Williams, Mr. Williams's recommendation, which was to impose a $100 fine payable to the Municipal Civil Infraction Department of the Wayne County, I believe it's the Wayne County Municipal Violations Ordinance Bureau, as well as Dr. Carnell's recommendation that it be filed to the appropriate bodies, the electing appointing officials, as well as posted to the county's website. With that said, if there's an adoption of the motion, is there an adoption of the motion at this time? Excuse me.
I adopt the motion. I think Mr. Carnell, I'm sorry. Mrs. Carnell already put the motion and I think I seconded it. So do we have to do it all over again? I just want to
yeah, because we tabled it, let's just do it all over again. So Dr. Carnell's motion is before the floor. Is there a second?
Second.
All in favor?
Aye.
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 All opposed? The ayes have it. So be it. Thank you, everyone, for that. We're going to move on to the next item of our agenda. The next item is item number D, which is new business. We have complaints from item number 1, which is complaints from John Sneed regarding multiple Wayne County officials. Mr. Williams and everyone, has everyone had the opportunity to receive the complaints from Mr. Sneed?
Yes.
Yes.
I did. Yes.
Everyone had the opportunity to review those complaints.
Yes.
Yes.
Is there any questions or concerns at this time?
No.
Members?
Nope.
Right. Mr. Williams, what is your recommendation regarding these complaints?
I made a recommendation to dismiss this complaint. I did not find that there had been a violation of the ethics ordinance, and I know historically, even though the board has evolved with new members, the board has been reticent about getting into sort of an oversight of various departments of the county and how they operate. This complaint appears to be against county officials in the implementation of their duties, and it's based on one, the appointment of a deputy by the sheriff's department that actually signs the deeds, the mortgage foreclosure deeds in the county. Ms. Felicia Mack. And Mr. Sneed seems to complain that Ms. Mack is not doing her job effectively or has occasionally signed deeds, or there are questions about the signatures on the deeds, even though there was no clear evidence of that presented. And that because she is not the undersheriff or the sheriff, she's not in a position to sign the deeds. My analysis is that that's just not correct under MCL 600.3216. So I thought that was an overstated claim. He also seems to have complaints against the prosecutor's office for operating a deed fraud unit, but being almost involved in what he believes is a conspiracy that supports the fraud underlying the deed, even though, again, there was very little evidence he presented in his complaint to support that claim. And he also has an allegation against the Register of Deeds, Mr. Youngblood, regarding the recording of deeds that he thought were defective, that had been signed or not signed by Deputy Mack. And again, under the statute that he cited, MCL 565.201, I didn't find that to be a viable argument, at least in terms of the language of the statute. So I am recommending that this complaint or complaints be dismissed. The second complaint appeared to be a legislative suggestion for how to fix what he believes is a problem in this mortgage deed process overall. But given his complaint for incompatibility of office and conflict of interest, my recommendation is that I didn't see it, but the complaint was difficult and complex enough and confusing enough that I thought it would be better for the board to see my recommendation. And having seen the complaints before, I just dismissed it as being not meeting the jurisdictional requirements of the ordinance.
So what is your recommendations this time?
That the complaints be dismissed as written.
All right. Is there any comments from any board members at this time with respect to the complaints from Mr. Sneed?
No comment.
No comment.
No comment from me.
Is there a motion to adopt Mr. Williams's recommendation with regards to the complaints?
I move to dismiss the complaint or complaint in this case.
Is there a second?
I'll second that.
All right, all in favor?
Aye.
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 All opposed? The ayes have it, so moved. Moving on to the next item of our agenda, which is item number 2, the advisory opinion request from Wayne County Board of Canvassers, member William Hart. I believe I'm just going to ask if all board members had the opportunity to review the advisory opinion requested from Mr. Hartman. I know Mr. Thomas has some concerns, so I'm going to open it up to members to address this. Mr. Williams, first let me go to Mr. Williams. I know Mr. Williams had responded to Mr. Hartman, so I'm going to open up to Mr. Williams first to first state what was being requested, and then to give us his opinion, and then we'll move forward.
Well, I think Mr. Hartman may be a sort of companion advisory opinion to Ms. Palmer. Apparently, Mr. Hartman has some business that he is a member of or owns that is advising political candidates in various counties in southeastern Michigan. And he is a member of the Board of Canvassers. He was concerned that historically he has not performed any service for candidates that were in Wayne County. He now has, as he represents it, a series of candidates that are in Wayne County. and that at some point, potentially, these candidates could find themselves in a recall election or some other election that comes before the Board of Canvassers, and he wanted an advisory opinion as to how to approach that situation in his role as a member of the Board of Canvassers. He indicated he had spoken to someone in the law department at the county and had been told that potentially the concept of disqualifying himself from any consideration of these candidates that come before the Board of Canvassers that he represents would be an appropriate mechanism for addressing the issue of incompatibility and conflict of interest related to the candidates that his company represents. I went through the ordinance and provided the board with a detailed sort of advisory opinion on the subject. Again, keeping in mind that I'm not sure that the ethics board is in a position to dictate how people do business or what business they can take and undertake. I think the language of the ordinance is clear enough that if a member of an appointed official to some board or commission or organization knows that they are going to end up in scenarios in which their clients are going to be before that board, it ought to be clear that perhaps they have to make some hard and fast decisions about whether to accept the engagement or to accept or to continue the appointment. That's my general view. That's the initial question. The disqualification, I think, is a minimal Band-Aid for the problem, but I think you should guard your conduct in a fashion that gives the public a measure of confidence that you are taking into consideration the potential for a conflict of interest when you're going to represent people who are running for office and then sit on a body that may decide issues related to a contested a contested election involving that very client. I think you would be better served in not accepting those clients, knowing the position, but those are the choices that you have to make as an appointee. It may or may not have consequences. I thought the better course of action is not to accept the Wayne County appointments, but he may not want to do that. At a minimum, though, he does have to disqualify himself, and that was the recommendation that I put together, having seen his request for an advisory opinion.
Okay, thank you, Mr. Williams.
You're welcome.
Is there any comments from any board members? I think, Mr. Thomas, you had some concerns before. Your question.
Yeah.
Go ahead, Mr. Thomas.
Yes, sir. Well, when I looked at the letter that Mr. Williams put together, I have to commend him. I think that it's an excellent letter, very well crafted. A couple observations I want to make. In this situation involving Ms. Palmer at the last hearing, and I hate to bring this up, but at the last hearing, a determination was made that since she had no financial interest, there couldn't be a conflict of interest. Board member spoke up and said, look, the only time we've ever found conflict of interest is when there's some type of financial benefit or some type of financial interest involved. So that is my understanding how we went to and why we went to the incompatibility issue. Here, if this gentleman did engage in something that circumvented what we may be telling him, there would be a conflict of interest. Why? Because there's financial interest involved. When I read this letter over, I truly wondered to myself how we could possibly say that this individual, that Mr. Hartman, accepting this position on the Board of Canvassers, would not of itself, in and of itself, be incompatible with his work if they're representing politicians. And I want to give you a couple examples. I should say representing politicians or would-be politicians, people that want to be elected. Let's say, for example, that Mr. Hartman did represent somebody in Wayne County and represented them at the primary stage. And he charged for those services. He got a financial benefit. And now that candidate loses. Doesn't matter whether it's Democrat, Republican, Independent, whoever he represented, they lose in the primary. Maybe it was kind of a bloody primary. We've had some of those in Wayne County where there's a lot of political elbowing going back and forth between primary candidates. So now his candidate that he had received money for in Wayne County has lost. They did not make it. But now in the November election, the candidate that opposed his candidate is going to be running for election, and he may have to count votes or do something else in his official capacity as a member of the Board of Canvassers. Another thing I'd like to point out, what this letter really does not address is what happens if Mr. Hartman's agency that he worked for, we don't even know the name of it, we can't look it up on the internet and find anything out and anything out about it. What would happen if his company represented somebody involved in a statewide election, let's say for governor or lieutenant governor or attorney general, a member of the Michigan Supreme Court? So now he's representing somebody in that area, in running for election for one of those positions. And he's not technically getting money. His company's not technically getting money to provide representation or some type of services in Wayne County. The whole thing just seems a little unseemly to me. I just don't know why an individual, a man or woman, who does this for a living, who it becomes involved in profiting off of individuals' quest for election to a position, why they would want to get a job on the Board of Canvassers. I honestly just do not see it. This seems to me to be a much more clear-cut case than Ms. Palmer's case. This is very obvious. The whole discussion regarding disqualification, recusal from a matter involving a client. I really appreciated Mr. Williams' letter where it said something to the effect that you can't be doing that on a repeated basis. If you're doing that knowing, if you're going to take this appointment, knowing going in that you're going to have to recuse yourself, maybe repeatedly, I just don't know. I just would have to say this. I don't know how somebody could represent candidates in other counties. We're not told that they're not going to represent anybody in statewide elections. We haven't been told that. But we're being told that it's only in Macomb County and Oakland County where he represents these individuals. But then, if one of these clients does run in Wayne County, he's going to disqualify himself. How does that help the public confidence? How does that help us do our job when people are trusting us to kind of oversee these individuals, their ethics and what they do and how they act in their official positions? I will tell you this. I heard Mr. Williams say a moment or two ago that if it's incompatible, there's a couple cures, recusal might be one. Just preemptively telling the individual that we perceive your involvement in political campaigns, even if it were just in the Tri-County area and not Wayne County. I just see it as a tremendous conflict. I actually tried to come up with some language to put in there, but I don't know how I would do it when to me it seems so clear cut that perhaps an individual whose living causes him to earn money from individuals' campaigns for election, why he would want to get a position, why he would seek out a position on the Wayne County Board of Canvassers, knowing that what Mr. Williams said in this letter is true. At a minimum, you've got to recuse yourself. And then when he recuses himself, I don't know what party he's from, but there's members of both parties on there. is he going to cause a situation where you can't get a majority vote? I just don't know. I just don't see it. And I really would have to say this, if I had to make a decision on this today, if I had to vote on something today, I think that I would just say that unless there's tremendous safeguards put in place, I think they're incompatible. I truly do.
Okay, thank you for that, Mr. Thomas. You raised several great points. And the chair had many of those questions also. Is there any other members that would like to chime in on this matter? Ms. Hamud.
Yes, I mean, I first want to thank Mr. William Hartman for at least asking for this opinion, because again, like we saw in the previous case we discussed, clarification, it sounds to me it's, needed. In my opinion, here, that will be not just incompatibility, and because now each time he needs to recuse himself, it will be basically the lack of ability to discharge his duties on this board, but also because there is monetary benefit, that would also be a conflict of interest if I'm making that decision today. Thank you.
Thank you for that, Ms. Hamud. And just from the chair, I'm just going to add a couple of quick comments as well. I actually found this very concerning because, and again, I did admire that Mr. Hartman came before this body and asked for an opinion. Hopefully he hasn't already engaged in this matter. It seemed like he has been, but it's admirable that he came and asked for an opinion. Possibly, as was mentioned, it seems like maybe some of the requests and the seeking the opinion came from the prior complaint that was filed against another Canvas member on his board. So it may have prompted him to seek this opinion. But I am one, or this chair is one, to believe that if you're in these positions, particular position where you're on the board of canvassers and you're overseeing possibly contested elections or what have you, you'd have to be a little bit above reproach. You can't have the appearance of impropriety. I mean, you have to have the appearance of impropriety. If you're on these boards and you're also working with political candidates, I would think it should be reasonably foreseeable that that will be a conflict or something that's incompatible. If you're working with candidates, maybe even if it's not in your own county, if it's in other counties, it would seem and appear that that would say that that just doesn't pass the test, or whether or not something is improper or not. I mean, it would seem to be clear cut. So again, this chair is admirable, admires the fact that he did ask for an opinion as to how he should proceed. I can understand that some people may be a little bit confused by some of the language in the ordinance. Maybe it's not as clear cut as to what we talked about before with the incompatibility. But again, I would agree with the recommendation that yes, he should possibly recuse himself from any of these, either from the board or from representing clients in this fashion. With that said, I believe the recommendation, you can state your recommendation again, Mr. Williams.
Well, I had put together a document that said at a minimum he had to recuse himself. Mr. Thomas has raised some very valid points that are broader and deeper. And unfortunately, Mr. Hartman is a victim of the lack of success of Ms. Palmer in terms of her defense of her action, in the sense of we know more about the Board of Canvassers today than any of us knew before November 3rd of 2020. We know what it does. I mean, as Mr. Schwartz said, most of us didn't know what it did at that point in time. Now we know. And there is an issue here, and I framed it saying, looking at how he phrased it, without considering, okay, suppose we have a federal election and he's representing a candidate that's running for a federal election that may appear before him. I think I'm right in the sense of he should not accept employment where it's going to involve candidates that are going to run for office that appear before the board of canvassers. If it has the potential to appear before the board of canvassers, he shouldn't do it. At a minimum, he's going to have to recuse himself, but I think he should decline the representation because his business is in fact a conflict of interest and a potential incompatible position if he's going to continue in the business of representing candidates for office that are running for election and may appear before the board on which he sits. At a minimum, he's got to recuse himself. I think he properly should not accept the engagement. And he's got to make a decision. Does he want to sit on the board of canvassers or does he want to continue to represent candidates?
Okay. And so your recommendation is that he needs to recuse himself, or is that?
Well, my recommendation is that he shouldn't accept the employment for representing candidates either that are running statewide or in Wayne County that may potentially run into issues that appear before the board of canvassers. If he elects to ignore that recommendation and accept the position, he at a minimum has to recuse himself from the consideration in the voting process with the board of canvassers. I know those are directly political appointments, supposedly appointed 2 people each from each majority party in the state. It may end up creating problems in the appointment and the ability of the board to function, but he does have to recuse himself at a minimum. My recommendation is he should not accept the engagement of those candidates. But if he chooses to proceed, runs afoul. I do think he has a real problem of potential conflict of interest, as Mr. Thomas has pointed out, receiving compensation for doing the work he's doing and sitting on the board of canvassers.
Okay, and thank you for that, Mr. Williams. Now, since this is not a motion, we're not going to be adopting the recommendation with respect to a motion. However, we're going to be looking at the recommendation with respect to the advisory opinion that we're going to give to Mr. Hartman. Now, Mr. Thomas, you had some other things that you wanted to add. Is what Mr. Williams just mentioned in line with what your position is with respect to this opinion from Mr. Hartman?
Well, let me just, if I could, Chair, I would just like to make something clear. I really, and I'm not going to do it unless other members share the concerns, but I really question the whole concept of Mr. Hartman accepting an appointment to the Board of Canvassers, knowing what he does for a living. That's number one. That would be my position. I'm telling you, I see the primary situations coming up in the future as being very, very, they could be caustic, and it may result in people coming to us and yelling and saying, well, why is he sitting on the Board of Canvassers? There's a conflict. These roles are incompatible. I did come up with some language, and this would be my recommendation. You look on the bottom of page 2, there is a sentence, at a minimum, recusal would seem to be the minimal course of action. And I played around with some language. I can read it now, and then what I could do is I could have it typed up and I could get it to Mr. Williams to take a look at. But the language that I came up with would be after minimal course of action. Does everybody see where that is? At a minimum, recusal would seem to be the minimal course of action, comma, in any situation where you, and this is what I'm suggesting to add, in any situation where you have represented or continue to represent a client in the election process, including a primary. That might be helpful. And then I think that one thing we have, another thing we have to add in, and I have to apologize, I could barely even read my writing, it's scribbled in red, but another thought that I would like to get out that I think we should include would be this. We've seen for the first time over the last 10 or 12 years where individuals who are running for elections statewide have teamed up together because of the cost of advertising. So in this last election, 2 Michigan Supreme Court justices aired advertisements together. They said, look, vote for us. There's 2 of us in here. Mr. Williams, with all due respect, what would our position be if if his company represented one of those individuals, but not 2 of those individuals concerning that advertisement? So I think the language that I came up with tried to encompass a situation where it's a little broader. I don't think that we could limit our advice to a situation where his candidate right now today, in November of any given year, is running for election. I fear that giving this type of opinion without those clarifications might be detrimental, including being detrimental to Mr. Hartman, because he might take it and rely on it and say, well, you know, if I do this, if my candidate in a primary lost, I can take part in canvassing the election in November. So those are my concerns. Those are my thoughts. I don't know if we feel this letter has to go out today, but I would really like the opportunity to run a couple thoughts by Mr. Williams to see if perhaps the other board members might not agree with some of the things that I proposed to him.
To the chair,
Yes, Dr. Cornell.
if Mr. Thomas is done.
Yes, I am.
I agree with Mr. Thomas. I would like Mr. Thomas and Mr. Williams to get together to strengthen the letter. The last thing I would want to happen is there is a complaint against Mr. Hartman is brought before the Ethics Committee and this letter is thrown in our face.
And the chair is going to agree with that. Ms. Hammoud, would you like to chime in on this?
Yes,
If Dr. Cornell's finished. Are you finished, Dr.?
I am, thank you.
Okay. Ms. Hammoud?
I agree with everything said. I believe that this is, as I stated earlier, if this is today, I would say there's clear conflict of interest and we can work on the language. So I agree with the recommendation to be able to either amend this because I'm assuming already this been sent or not. Is this recommendation?
No,
that
this
hasn't-
is
Okay.
just a recommendation, Ms. Mood. It has not been
Thank you.
sent.
Thank you.
Yes.
Okay, I just want to clarify that. So yeah, definitely, I like to have some changes. So I trust Mr. Thomas can work then with Mr. William, and then we can circulate it by email, or we can affirm the recommendation in the next board meeting before we send it.
Could I raise a point, Chair?
Yes, Mr. Thomas.
What I would suggest, if I could communicate with Mr. Williams, we could talk about it. I could send him some draft changes. I would just ask that, will I be permitted to copy you, Chair Pinkins, and the other members on it? Can I do that? Or would that violate something if I copied all the board members on what I send to Mr. Williams?
No, that would be fine, Mr. Thomas.
Okay.
It's just
Remember the
Open meeting.
opinion itself has to be approved at a
When a
board.
meeting.
Yeah, it's open. Now, Mr. Williams, did Mr. Hartman give a time frame that he wanted to see back this opinion?
Well, I think the ordinance sets a time frame for these advisory opinions.
I
Mr.
think
Chair.
90 days. I think
Yeah.
it's.
Yeah, we were within the time frame, I think we're still within the time frame.
I could probably get something to Mr. Williams by the first part of next week. I have to go out of town on business Thursday evening and I'll be out on Friday. But I may be able to get you something, Mr. Williams, and to the other board members by early next week.
That's fine by me.
Okay, so why don't we do this? Why don't the chair will adopt a recommendation to table this matter until the next meeting. That way we'll be able to work on it to fashion up an opinion for him that's suitable to all members. And we can table this matter to the next meeting if there's adoption to that motion.
Through the chair, this is Joe. It'd probably be better to do a pass for the day because it automatically will go to the next agenda if it's passed for the day.
Okay, well, thank you, Mr. Slizak. Why don't we do a pass for today on this item, and we'll retake this matter up at the next meeting. So excuse me, does someone have a question, Dr. Carnell? Someone had a question? Okay. Okay, if everybody is all set with this matter, we're gonna move on to the next item of our agenda. And moving on to the next item of our agenda, we have item E, which is such other matters as may be properly submitted before the board.
Mr. Pinkins, I'm sorry to step in again, but there needs to be a vote to pass for the day. I'm sorry.
Oh, I'm sorry. I'm skipping too far.
And there needs to be a motion in a second.
Okay, so going back to the second item of our agenda, which is the advisory opinion request from Wayne County Board of Canvassers member William Hartman. Is there a motion to pass on this item for today?
I move to pass this item for today.
And is there a second?
Second.
All in favor?
Aye.
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 Opposed? The ayes have it, so moved. Okay, moving on to the next item of our agenda, which is item number E, such other matters that may be properly submitted before the board. Are there any other matters before this board at this time?
Through the chair, it's Joe again. Just a matter of setting the date for the next meeting.
How does the schedule look for the next meeting, Mr. Slizak, for the third Wednesday of next month?
Third Wednesday in May, the 19th is open. There are no committee meetings scheduled for that day.
Did that work for all members?
It works for me.
All right. So we'll move the meeting. We'll have our next meeting on third Wednesday of next month, which is May 19th. I don't believe we have to have a motion for that. That's our general day that we normally have the meeting. It's the third Thursday of each month. Okay, so May 19th, 2021 at 9 a.m. will be our next meeting. Is there any other matter before this board at this time? All right, if there's no other matters, I'm going to move on to the next item of our agenda, which is item number F. Any public comments at this time? Any public comments at this time, Mr. Slezak, or anyone who knows?
I did not receive any, Chair, but I do just want to note that I'm going to reopen the chat at this point. So anyone who has a public comment to submit there can do so now.
Okay. We'll tell you. Okay, well, if there's no public comments, so just no further comments or any comments at this time, I'm going to move forward to our last item of our agenda, which is adjournment. The chair will accept any motions to adjourn at this time.
Motion to adjourn.
Is there a second? All in favor?
Aye.
Aye.
All opposed? This meeting is now adjourned. Thank you, everyone. Thank you for your time.
Thank you.
Thank you.
Thank you. See everybody next month.
All right, take care.
Take care.